Study Session 2. The Role of Law in Social Legislation. Introduction. In this lecture, discussion shall be on the concept of law and the role it has played in formulating social legislation. To do this effectively, it will be useful to understand what law is all about. We shall also consider the classification of law, functions of law, as well as the features of law. Objectives. At the end of this lecture, you should be able to 1. Discuss what law is. 2. Explain the classification of law. 3. Discuss the functions law performs. And 4. Explain the features of law. Pretest. 1. What do you understand by law? 2. Explain how law is classified. 3. What are the major functions of law? 4. What are the features of law? Law in modern societies has assumed a significant role as means of social control. Law can be defined as a set of rules governing the behavior and relationships of members of a society. It is promulgated and enforced by an appropriate authority. Law can also refer to the body of official rules and regulations generally found in constitutions, legislation, judicial opinions, and the likes, that is used to govern a society and to control the behavior of its members. History. In modern societies, some authorized body such as legislature or a court makes the law. It is backed by the coercive power of the state, which enforces the law by means of appropriate penalties or remedies. From the above discussion, we can regard law as the instrument by which society regulates the conduct and behavior of members of that society. Therefore, owing to the important place of law in human society, law inheres a certain amount of definitional problem. However, if we strip law of all its references in the sciences and economics, law can then be reduced to a set of rules that addresses itself to regulating human behaviors in all areas where these behaviors enjoy multiple probability recurrence, such as in business, family, on the street, the mass media, etc. In spite of this, however, there is an immense amount of conceptual entanglement when considering the meaning and nature of law. According to Alemica, 1994, the law is a command which obliges a person or a group of persons to a course of conduct or a change in behavior. Law, as a command, must issue from a determinate person or group of persons backed by some sanction to enforce compliance. Law has been defined as the outcome of what judges do. The focus of this definition is the legal process. This implies that law is a body of principles emanating from the decisions of specific cases, otherwise called stare decisis or precedents. The definition of law involves issues bordering on its sociality. In this case, law is seen as the nerve center, the bulwark of all the other environments. Law is the environment that seeks to legitimize and or engages in social engineering. Law is therefore a human instrument that operates in an environment that provides the legal basis for transactions among persons, real and abstract, and encouraging as well as discouraging those conducts of business that will advance social progress and growth or hinder such an advance as the case may be. Law may also be defined in terms of its purpose. In this regard, we can define law as a body of rules or principles recognized and implied by the state in the administration of justice. Mark Oliver and Ugiagwe, 2003, have attempted to synthesize the purpose and functions of law. They see law as providing the following: 1. Content, form, and direction to the common will of the majority. 2. The legitimacy for actions of citizens. 3. Means of guiding and regulating in most parts the behavior of others who are not indigenous, as or like a foreign investor who desires to do business in the environment of the guest nation. 4. Law helps to express, maintain, and sustain the sovereignty of states, and by extension, rights and duties of citizens, given that each nation has its own laws pertaining to local business and investments from abroad. 5. Law is an instrument of business, which the effective manager must learn to respond to. Change could come in the area of improvement demanded. It could be in fiscal or monetary policies, or the activities of competitors in industry, or legal requirements for welfare schemes and insurance protection. Classification of law. Law can be classified in many ways. In brief, these are the following. 1. Substantive and procedural law. Substantive law defines the rights and duties of persons, while procedural law defines and deals with the procedure for enforcing those rights. Number 2. Public law. Public law concerns the relationships between a government and individuals. Because the Rome codes were almost entirely limited to the private area, public law is usually not codified. In civil law countries, separate administrative courts adjudicate claims and disputes between the various branches of government and citizens, and many lawyers specialize in public law. In France, Germany, and Italy, still, other courts handle constitutional issues. Number 3. Private law. This involves the various relationships that people have with one another and the rules that determine their legal rights and duties among themselves. The area is concerned with rules and principles pertaining to private ownership and use of property, contracts between individuals, family relationship, and redress by way of compensation for harm inflicted on one person by another. Number 4. International law. This refers to the legal process that concerns relations among nations. Belief and experience in some form of international law dates back to at least the days of the Roman Empire. Such law differs greatly from national legal system. No court has the authority or power to give judgment backed by coercive sanctions. The United Nations is one of the primary mechanisms that articulates and creates international law. 5. Common law. Common law is a term used to refer to the main body of the unwritten English law that evolved from the 12th century. The name comes from the idea that English medieval law, as administered by the courts of the realm, reflected the common customs of the kingdom. This system of law prevails in Britain and in those countries such as Canada, the United States, and Nigeria that were originally colonized by the Great Britain. Number 6. Civil law. The term applies to all legal proceedings, whether taking place in a civil law or a common law system, that are not criminal in nature. Under this definition, law regulating marriage, contracts, and payment for personal injury are examples of civil law. Civil law is typically contrasted with common law, a system that evolved in medieval England, and that is the basis of law in most of the United Kingdom, Canada, the United States, and Nigeria. Number 7. Canon law. This is the body of legislation of various Christian churches dealing with matters of constitution or discipline. Although all religions have regulations, the term applies to the formal systems of Roman Catholic, Orthodox, and Anglican communions. It is distinct from civil or secular law, but conflict can arise in areas of mutual concern, for example, marriage and divorce. Number 8. Sharia Muslim laws. This is dominant in some northern states in Nigeria. They are classified as customary laws and are administered in Sharia, Alkali, and area courts. Cases coming before them are those pertaining to the family, succession, and inheritance, while their jurisdiction in criminal matters is limited. Number 9. Criminal law. This is the branch of law that defines crimes, establishes punishments, and regulates the investigation and prosecution of people accused of committing crime. Criminal law includes both substantive law and procedural law, which regulate the implementation and enforcement of substantive criminal functions of law. Law serves a variety of purposes. Laws against crimes, for example, help to maintain a peaceful, orderly, relatively stable society. Courts contribute to social stability by resolving disputes in a civilized fashion. Property and contract laws facilitate business activities and private planning. Laws limiting the powers of government help to provide some degree of freedom that would not otherwise be possible without those laws. Law has been used as a mechanism for social change. For instance, at various times, laws have been passed to inhibit social discrimination and to improve the quality of individual life in matters of health, education, and welfare. Are the purposes of laws as stated generally acknowledged by their framers and obvious to the target population? While typically there may be a public consensus as to the literal intent and purpose of some criminal laws, even if the purposes are not always agreed to, there may be other less obvious functions of these laws as well. For other laws, there may be little or no consensus on purposes at all. Not only do the manifest functions of laws require identification, so too do the variety of latent and indirect functions of it. These byproducts may in fact have given rise to the passage of laws. For instance, while tax laws are universally regarded as means of raising revenue, the variety of other purposes pursued through such laws may be less obvious to those affected by them, although clearly intended by the sponsors of the law. Their importance as mechanisms of social control, apart from revenue raising and spending, must be clearly acknowledged. Tort law provides another interesting example of the indirect social control functions of law. Tort law has evolved into a multifaceted instrument capable of pursuing simultaneously a variety of important, although not immediately obvious, social control goals. If early theorists of tort law did not discuss them, such social control functions of tort law are not viewed as unanticipated consequences of the purely private law of torts, but rather are considered a vital component of the conscious, although not publicly visible, development of the law itself. Such diverse governmental policies as crime control and workman's compensation have all had their roots in private law, field of thoughts, and such questions as general deterrence, income distribution, and industrial growth are now included in theoretical discussions of the private law of thoughts. These features of tax and thought law are not, however, generally thought of by social scientists in terms of social control. By and large, taxes are viewed as devices to raise revenue, and tort law, if taught at all, is viewed as a means by which private individuals can recover damages done them by others. But what may be regarded as a latent and inconsequential function for some may be manifest to others, and in modern societies, complex laws are likely to be adopted and supported precisely because they are capable of pursuing a variety of diverse purposes simultaneously. Because they are preoccupied with laws as commands, social legal scholars frequently do not cast their nets wide enough to identify these other kinds of laws or the multiplicity of functions of laws, and as a consequence, they often understand and ignore important efforts at social control. Efforts which are all the more important because they go unrecognized by a broader public, are frequently of low visibility and are effectively depoliticized matters for specialists and not for widespread public debate. Social scientists naturally tend to focus on celebrated commands and direct others of the highly visible policymakers who are grappling with the glamorous issues of the day. However, much governmental policy making is institutionalized in positions of law visibility with partial and fragmented responsibility. This observation, which has repeatedly been made with respect to the importance of bureaucracies in modern societies, is particularly applicable to courts in common law countries where important policies are not only developed in a fragmented incremental way, but are also effectively depoliticized. Efforts at social control through law can range from explicit commands to the manipulation of field controls of entire populations. The command approach envisions an ideal pattern of behavior for every individual within a clearly designated class. Field controls, on the other hand, are designed to affect the behavior of only a usually small portion within a target group by altering its field or environment so that some individual choices and behavior will be altered. Such manipulations of the environment are analogous to raising and lowering prices to affect demand, consumption, and substitution. This form of legal control is aimed at conditions and aggregates rather than specific individuals. Other functions of law are 1. Maintenance of public order. Public order is very important in every society, and without the rule of law and the court system to enforce it, each of us would be free to push and bully our fellow citizens and vice versa. We need law to protect us from the antisocial behavior of a few bullies, crooks, confident tricksters, and dangerous cranks. If we had no laws and no punishments, how many more harmless people would be robbed, swindled, murdered, or raped? Number 2. Law facilitates cooperative actions. This is most useful when it comes to business transactions based on the law of contract. In addition, a man living on his own on a desert island if he can cope, can behave exactly as he likes. As soon as a second person arrives, however, law becomes necessary to make them go along together. Number 3. Law communicates standards. When law defines rights and responsibilities and backs up its definitions with the threat of coercion, it becomes a powerful agency of communication. Every act of legislation is at the same time an act of communication. Therefore, it is important that there be close coordination of legal purpose and legal administration. Fairness, meaning law, at a trial may not offset the effect on public opinion of brutal or even disrespectful conduct by police at the time of arrest. Number 4. Conferring legitimacy. Law moderates the struggle for power by providing criteria of legitimate succession and by saying who has a right to exercise what kind of power. The legitimate function of constitutional law is the clearest example, for it sets out the conditions for becoming a president or Speaker of the House of Parliament. Number 5. Upholding rights and duties. In most human interaction, people have to accept the risk that others will not do what is expected of them. Being courteous, showing up for meetings, tending a neighborly hand, and many other expectations are important to orderly social life, but for the most part, they receive no legal recognition. Some expectations, however, are formally recognized and can be the basis of claims of rights. Such a claim, if it stems from a person's status as a human being or constitutional right, for example, the right to a fair trial or to be secure in one's home. Some experts believe the popular view of law overemphasizes its formal, coercive aspects. They point out that if a custom or norm is assured of judicial backing, it is for practical purposes law. On the other hand, a statute that is neither obeyed nor enforced is empty law. Social attitudes towards the formal laws are a significant part of the law in process. The role of law in England and the USA, for example, is somewhat different from its role in Nigeria and in other African nations. Respect for the processes of law is low, at least outside matters of business and industry, as tradition looms much larger in everyday life. Resort to legal resolution of a dispute is truly a last resort, with conciliation being the mechanism that is preferred for social control. Number 6. Law is not completely a matter of human enactment. There is also a natural law. The best-known version of this view, that God's law is supreme, has had considerable influence in Nigeria and other Western societies. The civil rights movement in the United States, for example, was at least partially inspired by the belief in natural law. Such a belief seems implicit in the view that law should serve to promote human dignity, for instance, the enforcement of equal rights for all. Muslim societies also embrace a kind of natural law, which is closely linked to the religion of Islam. Features of law. Before examining the different categories or classification of law, we will explain the meaning of the terms a law and the law as used in this text. A law refers to a particular act of parliament, a decree or edict in force, while the law refers to the totality or body of the laws of a nation, state, or organization. These laws include the various enactments, promulgations, judicial decisions, and decree, and other received English laws, and even the customs and traditions. The of these aforementioned laws refers to the laws of the state, as the case may be. Some of the features or characteristics that distinguish law from other social phenomena are as follows. 1. Law is a command. The law of modern states or nations is a command because all citizens and subjects are compelled, as it were, to obey it. The civil disobedience is another matter. On paper, the laws of the state are bound to be obeyed by the people. The state, through the various agencies, assign laws and departments, ensure that the laws of the state are obeyed by the people. Unlike norms, values and belief systems, mostly unwritten, but which nonetheless control and modify people's conduct and behaviors, laws give no room for choices. That is, it is mandatory and binding on all to obey the law. Failure to do so usually attracts penalties, as is the case of criminal law or liquidity for civil laws. Number 2. Universality. Law is in theory or nature universal, but in practice it is usually not. The provisions of law are universal because its purposes or intentions are usually meant to affect the generality of the people without exception. For example, the law prohibiting an act means that anybody, whether young or old, rich or poor, is prohibited from committing such act, and any offender will be treated equally or the same way by the law. In practice, it's usually not universal because some people are treated with levity and live above the law. Number 3. The law reflects the needs of the society. The human society is a dynamic one. Thus, as changes occur from time to time, laws are made to address such pressing needs that changes bring about. The laws of a police state ruled by a despot, a communist state, a socialist, capitalist, or other form of government or state going through turbulent times are good examples. The laws in operation in these different nations usually reflect their individual desires, goals, aspirations, and pressing needs. Whether such needs reflect the yearnings of the generality of the people, or the parochial and myopic whims and caprices of forgeries, incomprehensible megalomania, pimps and cohorts of psychopaths, praise singers, and even local and international allies, that is immaterial here. Number 4. Law is dynamic. Law, like any other social phenomenon, is dynamic. This dynamism usually reflects the changing needs of the society. As needs or development manifests, laws are enacted to deal with the changes brought about by such new developments. Some years ago, trafficking in human beings or drugs was unknown. Hence, there was no law relating to drug or human trafficking. Today, laws abound dealing with the evils of trafficking, child abuse, and so on. As new laws are made, old or existing ones are modified to reflect the needs of the people. For example, existing immigration laws of many nations, especially the European and North American nations, are changing to curb the influx of immigrants from poorer nations into their countries. Number 5. Laws are given by legitimate legal political authority. The term political here means a recognized and legitimate authority in the society, state, and even organization. Law is so called because there should be a known body authorized to perform such roles of making and enforcing laws in the society, state, or organization that makes them. In any formal organization, there is a recognized group of people who wield power and authority. Any law such authority enacts or mixed, so long as such law is within the dictates of such legitimate and political authority and not injurious to the wills of the generality of the people or make them subhuman in any way, it is regarded as a legitimate law. Thus, a group of people, no matter how powerful, cannot arrogate to themselves the power to make laws for the society until such collection of people is backed by the mandate of the people or section of the society. Study session summary. In this lecture, we have discussed the concept of law. In doing this, we also examined the various definitions of law, the purpose, functions of law. We also listed and discussed some features of law. That ends study session 2. Thank you for listening.